appeal. Is a state appeal.
Land Encroachment Act दीजिएगा.
My lord. Paragraph 4 and paragraph 6. Paragraph 4 is the fact. Paragraph 6 is was my submission before the Honorable Single Judge.
Yes. Land Encroachment Act.
Paragraph 4 is the fact and paragraph
14
6.
days was the minimum time.
Lord, my submission is that the purpose of the notice was just to inform, having an information to the person concerned. That notice was received by him
That
on the
ground you have taken before the single judge,
Lord,
which has been rejected.
My lord. And there, my lord, on that occasion, I had not submitted his judgment. There is a judgment of the Honorable Supreme Court where the Supreme Court had said even the statutory provision, even a mandatory provision can be waived. And it is not it will not make the order nullity. It can be termed as an irregularity.
You had argued this before the London single judge.
My lord, that finding is there at paragraph 6. Kindly permit me to read it, my lord. Mr. So-and-so learned counsel for the state submit that though the section 3 of the act requires not less than 2-week notice.
When was the notice issued?
On 9th.
9th?
I'm sorry, my lord. 9th of April 2014. 15, my lord. It has wrongly been typed as 2014 and it was received on the same day, 9th of April 2015. On 15th was the date fixed for hearing. The counsel appeared on that day and I filed a time petition because on the ground that document has not been provided to him.
Right.
That has not been accepted and it has been on.
And on the same day order was
passed.
We can't
then in form 2
now,
notice
therefore,
was.
Is this giving him appropriate time to represent his cause? No.
Lord, what I am submitting, Lord, on 15th it was he appeared. He had not filed any objection. Notice described the detail of the land. He had not filed any reply. Lord, it is not that the petitioner was not aware that he has encroached the land. The proceeding was continuing since 2008.
That's all right. Notice of demolition, notice of encroachment you issue on 9/4/2015. You dusty serve it on the same day. Now he files a petition on 15th. You have fixed it on 15th. He comes on 15th and says that he cannot effectively defend himself because these documents are required, or he has to procure documents. Now, is that sufficient? Especially when you are cutting short the statutory period after the notice when the case could have been fixed. Now, what justification? Because he appeared expressing his inability to explain his cause, you would take it as a necessary representation and a reasonable representation. Now, forget about the fact that notice is for the purpose of intimating the concerned person. He comes before you, not with response, but with demand of certain papers. Now, in that case, can you justify short-circuiting the entire process? Now the building has been demolished. You left him with no provision.
It was not building; it is a boundary wall, my lord.
You left him with no provision of appeal.
Lord, in the larger interest, public interest. Milord,
consider on quantum.
Milord, kindly permit, Milord,
consider on quantum, nothing else.
Milord, in the public interest, the collector has the power, Milord. Milord, kindly permit me to place the act. Though it is not directly, but I kindly permit, Milord. Section 3. Section 3 permits if it is in the public interest.
Has this order been stayed for a while?
No, Milord.
You have not paid him.
Notice was issued.
You have not paid him. No,
cost part has been stayed.
That part has been stayed.
Stayed, cost part has been stayed.
You need to pay.
Not, it is always similar. If Lord will direct, then
argue on the quantum, because the demolition was only with respect. Demolition was of the boundary wall only, and therefore this is too harsh. If you say that, we are prepared to lessen the amount.
Milord, I am ready for that, Milord, but kindly, Milord, it is subject.
But you must pay compensation. Milord, this is not the way in which you will handle things.
Milord, if you will also will kindly permit to place the fact.
Please.
Milord, even in 2008 notices was issued to him.
And that's true.
Milord, section 3 of the act.
You are not taking action on the notice of 2008, are you?
No, Milord.
Then you are taking action on the notice.
Pursuant to the notice of the 9th of April.
So therefore, whatever happened earlier, No, we are.
My lord, sometimes conduct
we
of the
are
parties is also important, my lord. It is a road. It is not
and
that.
your conduct is not to be seen.
My lord, my conduct is also to be seen, but my lord, in the public interest, government can. And my lord, even Mehdi Imam case, the division bench
That's
of
all
this.
right. Now, where was it causing any traffic snarl?
My lord,
Where was it causing any disturbance of any public utility
my lord,
building?
this is the finding, my lord.
This is the
3,000 people. It
No,
was, road
it's-
was blocked, my lord.
All right. So this is an argument with respect to lessening the amount of
My lord.
compensation, not for the purposes of justifying your act.
My lord,
I'm very clear about it. Not for the purposes of justifying your act, but for the purposes of reduction in the amount of compensation.
my lord,
उस पर law लाए हैं तो
may I
बताइए.
place section 3?
Yes.
My lord. Proviso, my lord.
एक मिनट section 3 पूरा पढ़ दीजिए.
It deals with the initiation of the proceeding.
Yes.
I am placing the proviso, my lord.
Now you read the whole of
From,
it.
if it appears to the collector from an application made by any person or upon information received from any source that any person has made or is responsible for the continuance of any encroachment upon any public land, the collector may cause to be served upon such person a notice in the prescribed form requiring him to appear on a date which shall not be less than 2 weeks from the date of service of notice to so cause. A, why he should not be restrained from making such encroachment by issue of injunction, or B, why such encroachment should not be removed.
Now read the last proviso.
My lord, provided further, my lord, first proviso I am
वो
reading.
ठीक है. We are not concerned with that.
My lord, second proviso, provided further that where the encroachment on public land is of such a nature as the collector consider its immediate removal essential for the safety of general public or for the safety of any other structure or the public land, and the notice cannot be served without unnecessary delay upon the person responsible for the encroachment or his representative owing to his absence or for any other reason, he may order the removal of the encroachment, or if necessary.
That's right. Now therefore, now we are
I am
pausing
taking
here.
advantage of this proviso.
We are pausing here.
I am not relying on this proviso, I am taking advantage of this
No,
proviso.
we will
My lord.
discuss it with you. Now, this is the proviso which gives power to the collector for immediate removal.
My lord.
Now, you cannot take advantage of this proviso for the simple reason that you had begun this exercise sometimes in 2008. Right? Therefore, there is no emergency. Where is the declaration that today in 2015 the matter had become
2008 we had not initiated. What had happened in 2008? Jila Prasad had taken an action against him.
Where is the declaration of the district magistrate? Because Miranda rule will apply here. You know what Miranda rule is?
No, my lord, I am sorry.
When you take special recourse to law, you need to jot it down. Right? So, where is the declaration of the collector that immediate demolition is necessary because of public utility?
My lord, I am placing that document. It is in the impugn order itself, my lord.
Which impugn order? Impugn order is appeal which has found your action to be absolutely
in the
bad.
read. The final order passed in the encroachment proceeding. It was a public road, my lord.
ठीक है, आप बताएं. We can consider lessening the amount provided we are satisfied. देखें.
Annexure C.
Let us see the order on 17 demolition के पहले order pass किया होगा
15th of April, then notice was issued in Form 2, and then demolition on 17th. 15th of April order, Annexure C at page 15 of the counter affidavit.
Writ petition.
Writ petition, my lord. Annexure C of the counter affidavit, page 15, type copy is there, my lord. May I read, my lord?
Yes.
पत्र एक का तामिला प्राप्त जो अभिलेख बंद है.
नहीं हमें गलत वो एक मिनट काउंटर एफिडेविट.
I am sorry, my lord. Counter affidavit filed on behalf of the respondent number 2. It was filed on 13th of July 2016.
Second. Counter affidavit on behalf of respondent number 2. When was it filed? No, these are
It
all
was filed on
internal.
13th of July 2016, my lord.
13th of July 2016. सब तो उन्हीं के डॉक्यूमेंट है, टाइप कॉपी सारे उन्हीं के मिल गया। हाँ बोलिए, which paragraph, which page?
Page 15, type copy is there, my lord. हिंदी में। वर्तमान नीचे 15/4/15 का ऑर्डर, सेकंड पैराग्राफ। वर्तमान अतिक्रमण वाद संख्या सो एंड सो खगड़िया में निबंधित है। उपरोक्त वाद कोसी कॉलेज खगड़िया के प्राचार्य श्री सो एंड सो के लिखित आवेदन के आलोक में प्रारंभ किया गया। आवेदन प्राप्ति के बाद अंचल अमीन खगड़िया ने भी अपना प्रतिवेदन में प्रतिवेदित किया है कि विपक्षी श्री शैलेश यादव के अधिवक्ता के द्वारा मौजा सोएंट्स का अंश भाग अतिक्रमित कर लिया गया है, जो कि सड़क की भूमि है। अंचल अमीन ने प्रतिवेदित किया कि सड़क की भूमि का अतिक्रमण कर 6 फीट गुने 4 फीट जमीन पर मकान दीवार खड़ा करा लिया गया है। वर्तमान में उस मोहल्ला अशोकनगर चित्रकूट में रहने वाले स्थानीय निवासी अभी कोसी कॉलेज की जमीन होकर आवागमन करते हैं एवं अभी सरकारी राशि से कोसी कॉलेज की 4 दीवारी का काम किया जा रहा है एवं कॉलेज का दीवार खड़ा होने पर उस मोहल्ला के लगभग 3000 से ज्यादा की आबादी को अपने घर से निकलने में काफी असुविधा होगी। Further, the DM, SDO, CO, all of them had inspected the place and they had requested him to remove the.
The structure was standing there since when?
From the record, it is there since 2008.
So therefore, you could have waited for him to say, we are not at all interested in allowing the structure, the encroachment to remain in place even for a minute. But proper procedure has to be followed. We don't find anything so emergent so as to justify the action under the proviso.
So the situation of the authorities is.
We are inclined to reduce the amount, but for that we'll have to notice the respondent.
Notices were issued.
Who appears?
None is appearing, but notices was issued on 25th of February.
Has it been served?
25th of 2000, I have not seen the office report.
Served? Validly served to respondent, there is no appearance. Now let you give a fresh notice. You have not paid him. He is also happy sitting back at home. Take steps for fresh notice. Will indicate in the order that we are inclined. Prima facie, we are not inclined to interfere with the order, except for the quantum of compensation.
कल बेंच बदल जाएगा तो दिक्कत होगी।
नहीं, quantum of compensation केवल कर देते हैं। That we are not able to justify this act. That's the reason. The quantum of compensation is very big, I must say. If it is on encroachment and it has not been questioned, but since you have not followed the procedure, you must pay. The government must pay. We are not fixing individual responsibility of the. Look here. The boundary wall of the respondent was demolished as it was found to be an encroachment on public road. The learned single judge, on finding that notice with respect to demolition was issued on 9/4/2015, which was served upon the respondent on the same day, was executed on 17/4/2015. Stop. Under Section 3 of the Bihar Public Land Encroachment Act 1956, stop. 15 days after the issuance of notice, a date is required to be fixed to enable the noticee to explain his cause. Stop. Only a week's time was given to the respondent to explain, and within 2 days thereafter, the structure, a boundary wall was demolished. Mr. Ajay, learned counsel for the state, while assailing the order which is directed for payment of compensation of rupees 5 lakhs to the respondent, has submitted that the sole purpose of issuance of notice is intimation to the noticee with respect to the proposed action. He further submits that because of the encroachment by the respondent, 3,000 people were adversely affected and they had no real egress from their respective houses. After having perused the records, we find that the notice issued on 9/4/2015, which was served upon the respondent on the same day, the respondent appeared on 15/4/2015, the date so fixed in the notice, only for seeking further time to explain as to how the structure was not an encroachment but on his Rayati land. Rejecting such plea of the respondent, the authorities proceeded to demolish the boundary wall. Mr. Ajay has further sought to assail the aforesaid order, finding the aforesaid order which finds the action of the state authorities to be preposterous, that such encroachment was there since 2008. Taking the aforesaid statement of the learned counsel for the appellant, we are of the view that there was no emergency in not allowing the respondent the statutory period of time for explaining his cause or for removing the encroachment. Section 3 of the Bihar Public Land Encroachment, the proviso, the last of the proviso to subsection 2 of section 3 of the Bihar Public Land Encroachment Act permits an immediate action where the encroachment on public land is of such a nature that it is considered to be that the authority considers it to be necessary to immediately remove such encroachment for the safety of general public or for the safety of any other structure on public land, and in that event, if the notice cannot be served without unnecessary delay upon the person responsible for encroachment or his representative, owing to his absence or from any other reason, there could be an order could be passed for removal of such encroachment, or if necessary, such encroachment could be caused to be removed immediately by using appropriate force. There is nothing on record to indicate that the existence of a boundary wall which was standing at the place from long before had caused any safety hazard for general public or for the safety of any other structure on public land. The background facts do not justify the action by the respondent even under the protective cover of the proviso to subclause 2 of section 3 of the Act of the Public Land Encroachment Act 1956. The action of the state/authorities cannot be justified. Even if it were an encroachment on a public land and was causing obstruction to the ingress and egress of local inhabitants who had their houses in the vicinity, that would not justify an action of this kind when it was not causing any safety hazard, under which condition only exceptional immediate action is contemplated under the Act. We thus do not find any fault with the order of the single judge who found the action of the respondent authorities to be bad in the eyes of law. Mr. Ajay, learned counsel, then submits that in such background, with such background facts, and there being nothing on record to indicate that the respondent challenged the assertion of the authorities or of the objectors that there was any encroachment by him on a public land, awarding a compensation of rupees 5 lakhs is not justifiable, On this issue, let fresh notice be issued to the respondent on steps being taken by the appellant within a period of 1 week, both modes, returnable on 1st of August. We have also taken notice of the fact that in the present appeal, notice was directed to be issued to the respondent, which has been served upon him, but there is no representation on his behalf. The order with respect, the part of the order with respect to, part of the order directing for payment of compensation of 5 lakhs to the respondent has been stayed by the coordinate bench of this court. For any reduction in the amount, or waiver, for any reduction in the amount of compensation or its waiver, the respondent is necessarily required to be heard.